This is part 40, and we will continue our discussion regarding general exceptions right from section 76 up to 106 of the Indian Penal Code, out of which by this time we have dealt with right from section 96 up to section 106 to understand as to what do you mean by right of private defense. Then we dealt with section 95 of the Indian Penal Code, which deals with act causing slight harm will not amount to an offense. And then, as I had told you during the last part, we shall now start discussing right from section 76 onwards. Now, in order to understand this part of the topic with which we are dealing, we will club two sections together, namely section 76 and section 79 of the Indian Penal Code. Now, if a police officer wanted to, Mr. A is accused of the offense of murder and he is arrested by the police officer, can it be said that police officer has committed the offense of wrongful confinement? The answer is in the negative, because it is police officer is bound by law, and when the police officer is bound by law to arrest the person who is accused of an offense, naturally that is a confinement, yes, but that is not at all a wrongful confinement, but it's a lawful confinement. It's what is known as apprehension. The police officer has arrested him as per the powers vested in him. So police officer is bound by law. Now, if you, this is one illustration, the illustration with respect to where the person is justified by law. If A is attacked by Mr. B and Mr. A repels the attack, and he has defended his body, which resulted into bodily pain to Mr. B. Or Mr. B tries to take away pain which Mr. A is having in his pocket, and Mr. A doesn't allow him to take away the pain for which he has used the force, which has resulted into bodily pain to Mr. B. Can it be said that Mr. A has committed the offense of voluntarily causing hurt? The answer is in the negative, because it falls under section 79, where we say he was justified by law. So now when we talk about both the sections, namely section 76 and section 79, first of all, if you start reading the section 79 says, nothing is an offense which is done by a person who is or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be bound by law to do it. So the person, when he is bound by law to do a particular act, then whatever act is done which he is bound by law to do, he is not at all liable as per the provisions of the Indian Penal Code. When there was a violent mob and the orders were given by the superior to fire into the direction of the mob in order to control the situation, he fired, which resulted into death of 10 persons. Is he liable for the offense of murder? The answer is in the negative, because he has done this act when he was bound by law. And now this is also the time where the person, we go to the next part. So both the sections, let me first of all, let go through section 79 also. It says, nothing is an offense which is done by a person who is justified by law, or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. So when the person is bound by law and he has done an act, that will not amount to an offense. When the person is bound, person is justified by law and he has done the act, he is not at all liable. And the second part of the section says that there can be, as he is a human being, there can be mistake of fact on his part. And if there is a mistake of fact, but it's what is defense? Mistake of fact can be a defense. Mistake of law cannot be a defense. So a police officer came to a particular, he came from one part of the country to another part of the country to arrest a person. And after due inquiry, after he wanted to arrest Mr. A, but after due inquiry, whatever procedure he wanted to follow, whatever method of investigation that he had resorted to, whatever was required to be done was done by him, and he arrested the person. But when he was taken to the police station and detained there for a period of 2 hours, it was found out that he, instead of arresting Mr. A, under the impression that he is arresting Mr. A, he had arrested Mr. B. and then after 2 hours police officer expressed apology, and then naturally set him free. But this person, namely B, who was at the police station, said, well, I was wrongfully confined for a period of 2 hours, and hence he wanted to proceed against the police officer. What is his liability? Or you just go outside the room, and the scene that is witnessed by you is that A has having a revolver in his hand, and he has pointed out revolver into direction of Mr. B. Now, what is the natural conclusion to which you can arrive? That Mr. A is committing the offence of murder defined by section 300 of the Indian Penal Code. You are to his back, so you catch hold of Mr. A and take him to the police station. Though he has not committed an offence, you said there was if you would not have caught hold of him, that would have resulted into death of Mr. B, and hence he is liable for a time. You wanted police to investigate the matter. Yes. But then when the police, police started with the investigation, it revealed that Mr. B had a knife and he started proceeding into direction of Mr. A in order to stab him. And what Mr. A was doing? A was exercising the right of private defense. Now you have taken a person to the police station who was not committing the offense of murder, but who was exercising the right of private defense. What you have done? It's clear-cut case of what is known as mistake of fact. And when there is a mistake of fact on the part of an individual, when he is bound by law and there is a mistake of fact, he is protected as far as second part. So classify section 76 and section 79 under two different heads. One, when the person is bound by law and when he has done an act, that act will not amount to an offence, because it says nothing is an offence which is done by a person who is bound by law to do it. And secondly, it says, or nothing is an offence which is done by a person who, by reason of a mistake of fact and not by reason of mistake of law in good faith, believes himself to be bound by law to do it. So whatever, there is a mistake of fact because of which he believes in good faith that he is bound by law to do it. And same is the case as far as section 79 is concerned, which says nothing is an offence which is done by a person who is justified by law, or who by reason of a mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. In other words, this is also justified by law or when there is a mistake of fact. But mind well, in order to get protection as far as these sections are concerned, it's must that the person, when he is bound by law, he had acted in good faith. And secondly, the person, for example, who is justified by law, when he was also doing that act in good faith. And this is the time for us to understand as to what do you mean by good faith. And in order to understand good faith, as I had told you, this is the time for you to have a reference back to general explanations, out of which you have to read section 52, which says, what is the definition of good faith is in the negative form, which says nothing is said to be done or believed in good faith which is done or believed without due care and attention. Nothing is said to be done or believed in good faith which is done or believed without due care and attention. So this is exactly the relative term. What is due care? And we shall be coming across this term good faith at the time of discussing various general exceptions with which we shall be dealing during course of our lecture. And hence now, if what is good faith? It is a relative term. If the act is done with due care and attention, then it can be said that it is done in good faith. If there is no due care and attention, and then this is the time due care and attention speaks about as far as the objective test of the mind. When it's not that, whatever he thinks, no, certainly not. There must be due care and attention on his part. And if it is not done by him, then we say the person is not at all protected as far as maybe as far as section 76 or section 79 of the Indian Penal Code is concerned. Now, the case where police officer saw that somebody was running, and because of the fact he was running, police officer immediately went and caught hold of him, because he was under impression that he might have committed the offence. That is the reason why he is running, or he is running because he wants to commit the offence. And when he was taken to the police station and detained in the police station for a period of 2 hours or so, ultimately it revealed that police officer, this man had very urgent work, he had some problem, so he wanted to get medicine as early as possible, and hence he was running. Now, what was, can it be said that the police officer is protected? The answer is in the negative, because the police officer, there may be a mistake of fact, no doubt about it, but the police officer has not acted in good faith. And why we say that he has not acted in good faith? Because there was no due care and attention. At the time of arresting a person, it was must for the police officer to ask him as to what is the reason, why are you running? And then if the police officer, the replies were not certain, because of the replies the police officer was not satisfied, yes, he could have taken him to the police station, no doubt about it, into the custody for the time being, no doubt about it, but otherwise not. So this is due care and attention on the part of the police officer. And hence, if it is not done by the done on the part of the police officer, then naturally what we say, he is liable for the offence of wrongful confinement as it is defined by section 340 of the Indian Penal Code. So this is exactly to understand, and this is the time for us to understand as to what do you mean by good faith. And hence now imagine one illustration where because of which it will be possible for you to understand whether the person has acted in good faith or not. A police officer started from his residence in the morning, and the father called him and told him, son, there is a problem, somebody has committed theft with respect to our horse. Police officer says, I am on duty, I am going on duty, don't worry, during course of time I will start with the investigation. While proceeding towards his duty, namely the police station, he saw that the horse which resembled that of his father's or that of their family was tied in front of the house of somebody. He straightway went to the person and asked him, how is that you are having this horse? He said, well, I have got this horse from I have purchased this horse from Mr. A. Police officer asked him, do you know address of Mr. A and details? He said, by all means. Police officer straightway from there went to the place of Mr. A, arrested him, brought him to the police station and compelled him to sit there for a period of 3 hours or so. And then the police officer wanted to start with the investigation. But then before he could start with the investigation, he receives a telephone call from his father stating, don't worry about the horse. The horse was taken by the guest for the purpose of riding, and the guest is back along with the horse, so nobody has committed theft with respect to the horse. This man, who was detained at the police station for a period of 3 hours, went to the court of law and wanted to proceed against the police officer for the offence of wrongful confinement defined by section 340 of the Indian Penal Code. I presume now that when we talk about wrongful confinement, you know what is wrongful confinement, and hence now where I refer to particular offence, you must be aware of that offence, because we already dealt with that offence. What is liability of the police officer? And then we say police officer is liable. Why? Because he has not acted in good faith. Why we say he has not acted in good faith? Because there was no due care and attention on his part. Why we say there was no due care and attention on his part? Before taking A to the police station, if you would have asked him a question as to how is that you are having this horse, and he would have replied by saying, well, I have purchased this. And then he would have gone to the place from where he had purchased and would have come to know the details regarding the horse, because this is that you can have animal which resembles your animal also, no problem. But simply because of the fact that you saw animal which resembled horse which resembled that of your father's, you immediately jump to the conclusion there is no due care and attention on the part of the person, and hence what we say, this is due care and attention will entirely depend upon the facts of the particular case. And hence generally when officer in charge or the person who is in charge as far as dispersal of an unlawful assembly is concerned, what is the practice that has been followed? If the crowd has started becoming violent, the first order that is passed, the order that is given by him is to disperse. if the crowd doesn't disperse or they continue their assembly over there, then he can say charge means he can start with the lathi charge also. If that doesn't serve purpose, there can be tear gas also. If that doesn't serve purpose, the police in charge can say fire into the direction of the air, so that everybody will come to know that, well, we are having guns and the guns may be pointed out into your direction. And if that doesn't serve the purpose, firing into the direction. I mean, this, though I have narrated the steps 1, 2, 3, 4, this depends upon situation. If a violent mob attacks police station, the police officer, cannot follow this. He will immediately take out revolver and say, stop, otherwise I will fire. And he can fire, so there is a due care and attention. Hence what we say, due care and attention is a relative term which varies according to the circumstances, facts and situation of a particular case, of which you have to take note. And hence now, this is the case where if the person, for example, is, we go back to section 76, we say, if the person is bound by law, and then he has done an act that will not, that will not amount to an offense, this is a protection which is given to the person who is bound by law. Not only that, as far as section 79 is concerned, it says the act done by a person justified by law or by mistake of fact, believing himself justified by law. So there can be mistake of fact, no doubt about it, which can be a defense. But if there cannot be mistake, for example, if the police officer has arrested a person and the person has not committed the offense which is a cognizable offense, which is a non-cognizable offense. Now when you will deal with the provisions of the criminal procedure code, you will come to know, in case of cognizable offences, police officer has got right to arrest a person without warrant, and he can start with the investigation without any order from the court of law. So there, if he has arrested a person, and in case of non-cognizable offences, he has neither right to arrest nor to start with the investigation unless there is a direction which is given by the court of law. So here he has arrested a person. Now this is what? Arresting a person who is accused of an offence of non-cognizable offence when he has got no right to arrest. This is mistake of law, and hence the police officer is not at all protected, because this is a case of mistake of law. Understanding, ignorance of law cannot be an excuse. You must know the provisions of the law, and you cannot come out with a defense and then I was not knowing the particular provision of the law. And with this now, as I told you, if you go on reading the illustrations simultaneously wherever you come across the illustration to section 76 says, a soldier fires on a mob by the order of his superior officer in conformity with commands of law. So you can obey the orders, but how the orders must be? Orders must be lawful. If your superior tells you to fire into a direction of a mob which is docile, which is not at all violent, you won't be protected, because it can be said that which are the orders which are required to be obeyed by you? The orders which are lawful order, and hence good faith plays very important role from the point of view of understanding. The second illustration speaks about an officer of a court of justice being ordered by that court to arrest Y, and after due inquiry believing Z to be by arrest Z, A has committed no offence, because this is a case of a mistake of fact, provided, as I have told you the illustrations with which you are there, provided he has acted in what is known as good faith. And in order to understand what do you mean by good faith, as we have to refer to section 52, we said nothing is said to be done or believed in good faith which is done or believed without due care and attention. We shall be dealing with this good faith during course of our lecture, no doubt about it. But for the timing, if this is understood by you, that if the person, in order to get benefit, as far as section 76 or section 79 is concerned, he must act in what is known as good faith. And hence when you refer to two sections, namely section 76 where the person is bound by law, where he has done an act which is bound by law, he is not liable, and section 79 when the person is justified by law, that is one thing. and in both the cases there can be second part of the section tells you as far as section 76 and 79 is concerned, when the person is bound by law, there is a mistake of fact and he has acted in good faith, and when the person is justified by law, there is a mistake of fact, but if he has acted in good faith, he is protected as far as section 79 of the Indian Penal Code is concerned. With this now, the time for us to understand two more sections with which we will continue our discussion during as far as next part of our lecture is concerned, where we shall be dealing with section 77 and section 78 of the Indian Penal Code. Section 77 deals with the cases where act of a judge when acting judicially, and secondly, section 78 deals with the cases where the act done pursuant to the judgment or order of a court, with which we will continue our discussion as far as next part of our lecture is concerned.